Hello everyone, my name is Anita Igwe, and today I'm here to give a presentation on Andrews versus Law Society of British Columbia 1989, which is based on the equality rights in Canadian law. Today, I will take you through a foundational Supreme Court case that redefined the equality in Canada. Andrew versus Law Society of British Columbia, while it's a constitutional law case, the lesson from it teaches deep into leadership, business, and the principles that guide equitable organization. The background of the case. Matthew Andrew, British citizen, permanent Canadian resident, met all the criteria to become a lawyer, except citizenship. He was denied by the Law Society of British Columbia, which made Andrew challenge the rule on the ground of the rule being discriminatory. And this situation opened the door to the first big interpretation of equity right under the Charter. The equity clause, it says that every individual is equal before and under the law and has the right to the equal protection and equal benefits of the law without discrimination. The Section 15 of the Charter guarantees equity rights. Now, how do we define equity? Is it an identical treatment or fair impact? With the case of Andrew and the Law Society, he gave us answers to these questions. The legal question whether denying a non-citizen the ability to practice law was discrimination, going by what we saw in the case of Andrew and the Law Society. Even though the rules seem neutral, the court had to ask, does the law disadvantage people based on who they are? Which was the question that was asked under the discrimination under Section 15. Which going by Section 15, it says that if you're denying people to practice law because they don't have citizenship, and from what was gotten from the court case, it was seen as the rule violated the Section 15 on the basis of discrimination. So the courts despite the courts ruled in favor of as they went to court, the courts ruled in favor of Andrew. They declared the rule unconstitutional because it discriminated against permanent residents despite their qualifications simply due to citizenship status. The equality test under the legal principle, every individual is equal before and under the law and has the right to the equal protection and equal benefits of the law without discrimination. Section 15 of the Charter guarantees equality rights. The legal question whether denying a non-citizen the ability to practice law was discrimination, even if the rules seem neutral. The court saw this as putting people on a disadvantage because of they didn't meet a particular, maybe because of their race, because of their religion, or because of maybe who they are. which under the Section 15 was seen as violation of the equality rights. The courts ruled in favor of Andrew. They declared the rule unconstitutional because it discriminated against permanent residents, despite their qualifications simply due to the citizenship status. So moving on to the next. Why I chose Andrew versus the Law Society of British Columbia. I chose Andrew versus the Law Society of British Columbia because it is the Supreme Court's first and most influential case. It interpreted the Section 15 of the Charter clearly. It is particularly interesting to me because it established the framework for analyzing equality rights in Canada. Not based on how similar people are, but how law affects them differently. It is about real world, not just surface fairness. The case is the cornerstone for understanding how Canadian law protected against discrimination, especially in the professional and in business context. Judicial application and expansion. Justice McIntyre, writing for the majority, fundamentally shaped the interpretation of Section 15. He rejected the similarity situated text, which was rooted on formal equality. Now, formal equality has to do with treating everyone the same, and he adopted the subjective equality. The subjective equality had to do with addressing unequal impact, right? He made it clear that treating people the same isn't enough if the result is still unequal or harmful. The law is truly fair, is truly not fair. This distinction remains essential in the human rights and the diversity strategies in today's world. He also articulated that discrimination, whether intentional or not, involves a distinction based on personal characteristics that imposes disadvantage or limits access to benefits. He emphasized that Section 15 is remedial and propositive, aiming to ensure that all individuals are recognized as equal, deserving of concern, respect, and consideration at law. The court established a two-step text. One, does the law create a distinction that results in unequal treatment or impact? Number two, is it distinction discriminatory, meaning it poses a disadvantage or withholds a benefit based on a personal characteristics? This approach expanded the definition of equality in Canadian law, moving it beyond just the meaning, but to how people are being treated. So now coming to the relevance for business leaders. This case had a lot to do with inclusivity in both the hiring processes, non-discriminatory policies, compliance with human rights laws. So now the main question here is, what does this matter? How does this matter to the future leaders? It teaches us that fairness isn't about box checking. Business must look at outcomes. Who is left behind? Are policies unintentionally discriminatory? Inclusion is about results, not good intentions. This policy also helps prevent costly legal issues for businesses. It builds trust and equality in organization. It provides peace of mind and inclusion. From the strategic perspective, This case reflects multiple types of value. Legal compliance avoids lawsuits, inclusion policy build loyal team, and employee feels seen and respected. And also, I feel that this also challenges the traditional business model. The traditional business model has to do with equity through uniform policy, while the modern business model has to do with equality through personalized support, which I feel this case portrayed. The case challenges the traditional business model that claims neutrality towards equity, which recognizes different needs and reality to the level of in the playing field. So I feel that from okay, coming to the decision and remedy, the Supreme Court found that the citizenship requirement for admission to the bar was discriminatory and violated Section 15 of the Charter. The court held the citizenship, though not enumerated in Section 15, was an analogous ground for discrimination. The Law Society rule imposed a disadvantage on permanent residents, limiting their access to the legal profession without substantial justification. The court also considered whether the infringement could be justified under Section 1 of the Charter, which allows reasonable limit on rights. It concluded that the Law Society rule could not be justified and which caused the requirement was struck down. The remedy was to invalidate the citizenship requirement, allowing Andrew and other in his positions to be admitted to the bar. In conclusion, Andrew's case didn't just change the law, it changed how we think about fairness. Whether you're crafting a hiring policy or building a team, this principle helps ensure equal opportunity actually means something. The law must not only treat people the same, it must also recognize when sameness creates inequality. Andrew and the Law Society of British Columbia teaches us that equality isn't abstract, it's about decision. And as future leaders, we can carry this understanding into everything we build in our workplace, our teams, and our legacy. Thank you.